All right. Well, good evening, everybody out there, and thank you for joining us today at Brother Counsel. And as you know, you guys are probably not here for me today, and that's for good reason. We have a very, very special guest. It's truly a real privilege, a real honor for me to be able to have on Karen Reed's legal team, some of the legal team at least, that are willing to come and join Brother Counsel. And I do have, for all of you, I know that you know that I like to ask different types of questions. I look at these cases a little bit differently than maybe the average law tuber or whatever. But I have a list of questions. They haven't really limited me on what specifically I'm allowed to ask. But obviously, if I start asking questions which they cannot answer, then they're just going to tell me they can't answer. It's confidential, attorney-client privilege, whatever it is. So the most that I can do for you guys is ask the questions. And hopefully we'll get, if not the exact answer that we're looking for, maybe we'll get some other ideas or thoughts on the matter. So without any further ado, let's bring on Bob Alessi and David Yannetti. Welcome to the show. And I got to tell you, I'm really, really humbled, very, very humbled, the fact that you, as probably the biggest celebrities right now in the country, are willing to sit down with me, a very humble and small channel here, to discuss the trial. So I just feel humbled and just thank you so much.
Very excited to be on, Martin.
Yeah, Martin, thanks for having us on. I mean, we're, as you can see, we're trying to go on these YouTuber shows, people that really dived into the case and, smart commentary and, extended format. So very happy to be here.
All right. Well, thank you so much. I'm glad to be within that company. Lawyer, Melanie Little. These are the people that we look up to and hope to be one day. So, I'm kind of on my journey. So hopefully we'll get there, but really very much appreciate it. So let me dive right into it. Something that I always talk to my channel about is about jury selection, how important it is, jury selection. It's something that we don't get to see from the outside. They don't live stream. We just hear certain reports from the people in the courtroom. And I always tell everybody how you can really tell the skill of a lawyer just by the way that he conducts jury selection. However, from the reports, I heard that this jury selection, you are kind of handcuffed in a very significant way. Is there anything that you can share with us about how jury selection happened in this case and why it seems very different than in other cases and how you kind of dealt with those type of challenges? Anybody who wants to take it?
David, you're the Massachusetts person. I've done jury selections all over the country, and that's my best ways to duck the first one and give the hard one to David.
Well, I guess I would throw the question back at you, Martin, and you say that we were hamstrung. Can you be more specific about what you've heard?
So what I heard was that the attorneys were not allowed to ask questions directly to the jurors. There was no interaction between the attorneys and the potential jurors. That was number one, which is, to me, that is when we begin our relationship. That's when we begin connecting with the jury, seeing which one kind of, opens up to you. You kind of get a very good feeling when you're able to interact with the jury. So that's what I heard you were not able to do. And number two was the fact that you had to use your preemptory challenges before you had a full 18-person juror in front of you. So those are the two things that I heard, which to me seem very challenging. I want to know, okay, I got these 18 guys on the jury, 18 people on the jury. I may not like one, but I like four a little bit better. Okay, if I'm going to use a preemptory, I'm going to use it on him, not her. So were those two things accurate? And if so, how did you approach it?
Okay, so I can give you sort of a general background on how jury selection is typically conducted in Massachusetts. And I can talk in generalities about this case without going into too much specifics, but I'll do my best to answer that question. So, in many jurisdictions, attorney-conducted voir dire is commonplace, happens all the time. The attorneys, the attorneys for each party basically control the questioning. Panel voir dire is very common. In Massachusetts, it's not. There was a pilot program put in place a few years ago where we were trying to transition to that as opposed to just having the judge do the voir dire after receiving questions in writing from the attorneys. But it never really stuck. And most judges, I think, are, sort of set in their ways. Submit your voir dire questions. I'll tell you what I'll ask or not ask. And then, there are some judges that just adhere to that. Many judges, however, will, despite the fact that the judge is asking the questions, they will allow the attorneys to then chime in with additional questions after the judge finishes his or her questions. Again, I can't get into specifics about what was said or not said at sidebar, but I will tell you that I did not feel as though we were hamstrung in our questioning of jurors and jury selection. We made good use of, I think, all our peremptories, or just about all our peremptories. But we were, I think, given free enough rein to really try and weed out anybody that might come to the case with a potential bias or prejudice. So I can only speak for myself. Maybe Bob has a different view. Maybe other members of the team have a different view. But I feel like we have the tools that we need to pick a good jury. And I am so happy with the jury that we picked. I thought they were phenomenal.
Yeah, Martin, what I would add to it is this. I did not feel hamstrung much at all. The only potential hamstring that could occur was time, just the way Massachusetts does their jury selection. You got to move pretty quickly. But in terms of the substance, we asked questions directly of the jurors. We talked to them. We looked at them. We were very close physically just because of the nature of the courtroom and the need to have confidentiality of what was said. I thought Judge Cannoni provided us with as much opportunity to evaluate the jurors as any jurisdiction I've been in. With regard to skills necessary and the importance of that, you couldn't be more right. Many cases, as you know, can be lost at jury selection, and certainly cases can be won at jury selection. I felt that we as a team, and we conducted the jury selection as a team, the three of us asking questions, we'd rotate in and out asking the questions. And I thought the team performed extraordinarily well with jury selection. And like David, I was very pleased with the jury we picked at the time. As I sat through the trial, this was a very professional, strong, and attentive jury. And based upon what I've heard, and I haven't heard a lot, but what I've heard from the jurors has only confirmed what I believed all along about the jury selection process. So in conclusion, I think the jury selection process worked, and I'm very proud of the team for the job that the team did in selecting the jurors.
Okay, so just to be clear, you were able to interact with the jurors, potential jurors, right?
Oh, yes, and frequently and directly and often. Yeah.
Okay, great. And not only that, but it seems from your answers that not only one of you were able to interact, a bunch of you were able to interact with the jury.
Right. Well, just one attorney per jury. We couldn't, keep tag teaming with the same juror, but, one attorney would step up from the defense team and ask questions of the jurors and see that juror through the entire process. And with regard to peremptories, we had to exercise our peremptories right on the spot. You didn't wait until the jury was impaneled.
So that's what I feel is also a tremendous challenge. When you don't see the full jury pool in front of you, how do you know, I don't like this person so much, but who knows, maybe the next person up is going to be worse. I don't want to waste it.
Let's make a deal. Do you want to take what you have, or do you want what's behind door number 3? Right. Believe me, it all played into the mix. And, naturally in those scenarios, you are looking ahead at the juror questionnaires of who might be coming up, and you're judging, not crazy about this person, but boy, I'm really afraid of the next person. Maybe we just should cut our losses here, I didn't feel like we ever had to cut our losses. I was happy with with every juror that we picked. And I would also note, in terms of this being a disadvantage, both sides had to play by the same rules. So, give us a set of rules, and I feel like this team was going to beat the other side using those sets of rules. That's how I felt.
Yeah, no, okay, I agree with that. So, okay, it's good to get some information on that, because I guess some of the reports were inaccurate. So I appreciate that. Let me just kind of move on to opening statements. I'm not sure if we're going to be able to answer this, because everybody knows that you opened in the first trial. You did not open the second trial. Is there anything at all that you're able to share with us with that, or should I just move on to the next question?
No, not really. The only thing I would say is that every attorney on this team was fully invested in achieving the goal, and whoever was standing up, had. How many attorneys did we have on the team? We had 1, 2, 3. We had 3 other attorneys, behind them, working with them, pulling for them. I wouldn't have changed the thing.
Yeah. Okay. Yeah. I'm just wanting to know, because there's a difference, and people are wondering about that. But I understand that there was a very strong team effort. I know Alan Jackson said a number of times there is no quote unquote lead attorney here. We're all working as a team. So you definitely saw
we did.
that.
Yeah, and that is absolutely right. The team worked as co-equals, and among many other reasons that led to the successes that we had.
So let me talk about the team for a moment. So the team was the team, and then kind of at the 11th hour, Bob Alessi joined the team, and it seemed very clear that you were brought in to deal with the experts, which proved to be a very smart idea. But so you came in, Bob Alessi, right? You came in to the case. The first thing that I'm wondering is, I've been brought into cases at the 11th hour to try the case also, usually because the lawyer doesn't want to try the case and he wants to give it to someone who's willing to try it. So they bring me on and say, hey, try this case, trials in a week. So I got a file to go through. Here, you're joining this case. There's already been a full trial. The discovery on this case, must have been terabytes. I think a lot of people want to know, when you're joining the case at that point, what's your process and how to dig into the file? Are you reading everything? Are you looking at the last transcripts? Are you watching the other trials? Like, what are you doing? What's your process in order to get caught up what you need to be for this trial? Not only, by the way, which I assume you didn't do just to deal with the experts, but also to be able to be helpful for the strategy of the entire trial, which means you have to have a working, really good knowledge in the entire file. So what's your process? And I know you keep crazy hours, but you come in at the 11th hour, like where do you start?
Yeah, the short answer is I read everything, and I stay up until I'm done reading everything, and sleep as little as possible in that regard. Specifically, I read the transcripts from the first trial. I read not just expert testimony, I read everyone's testimony. I also had a significant advantage. I would hector David Yannetti, say, hey, I read this, I did this, what about this? What about this? Why did we do this? Why didn't we do that? And David was incredibly gracious and made himself available for me to bounce things off of him. But it's simply a time commitment and a commitment that you're going to read everything possible with regard to the case. And my role expanded significantly from the very start until the very end. So I was very fortunate and glad that I had read everything. But it's pretty simple. You read everything, you make the time commitment and go in. And the other is, I absolutely love practicing law. And so to me, it's a joy. It's just okay, to be able to reading it. It's obviously a very interesting case. And I love the science and the technology and the physics, everything about it. So, some people like to read the bestsellers all the time. I like to read transcripts and expert reports.
And what was it like to get a shout out from David Yannetti, when he was making your motion for pro hoc vice, saying that he doesn't know a better trial lawyer in the country? I mean, I would just retire the next day after hearing that from David Yannetti, you know?
Well, David Yannetti is hands down the best criminal defense attorney in the greater Boston area. And I would say, from my experience throughout the country, and to get that type of praise from David Yannetti, I didn't consider retiring the next day, but I did say, I don't know if I'm ever going to get a bigger compliment from a more prominent attorney. So it was great encouragement coming from David and just more motivation to do well.
Yeah. And then, so talking about when you came in, so you're coming in, you got this tremendous file to review. You got all the transcripts of a 30-day trial to review, the discoveries of Illuminous. And then, you get thrown this curveball with the grave concern, as, we come to know it by. And then, the team seems to turn to you to handle it, which you did very effectively, obviously. But while you were handling it, and, maybe I'm overstepping my bounds, which is, what I guess, okay for me, but if you don't want to answer, that's fine. Was there a moment when you're talking with David and thinking, she may just take away his pro hoc vice, Alan Jackson, Eliza Little, and it may just be us two? Were there any sort of moments like that where we may have to handle this case ourselves, and what are we going to do if she revokes Alan Jackson's pro hoc vice?
There was a fleeting moment in my mind when that came about. And what I mean by fleeting, maybe 5 seconds, and my immediate mode went into defend, prevent, in no way that I can have that happen. And I dug in for 8 days straight, very little sleep, in getting prepared for that. And my mentality and my whole approach after that 5 seconds was I was going to do everything humanly possible to protect AJ's pro hoc vice and Liza's, but it was more AJ's, because we all know if you get your pro hoc vice knocked off in one state, you're going to have difficulties in other state, and it could have had a very, very impactful effect on AJ's practice. So I didn't give much thought beyond those 5 seconds to it. My view was I'm at point A, I got to get to point B, and point B has got to be AJ's got to stay on the team. He's an important member of the team, and to achieve our goal, we needed to have AJ on the team.
Right. I mean,
what Martin, I'm sorry to interrupt, but what this illustrates is that, if you're in trouble, any kind of trouble, there's no attorney in the country that you want speaking for you other than Bob Alessi. I mean, I had a front row seat to his preparation, and he took this as a personal affront. It's not as though he had a long history with Alan and they were best buds going back to high school. It did not matter. This was a potential attack on a fellow member of the defense team. And, Bob's attitude is, you ask if he had any, concerns or is it going to happen? Bob's attitude is, no, it's not going to happen because I am going to prevent it from happening. And he, pulled out all the stops, did every ounce of preparation, and his advocacy was, you saw it in court. He's just phenomenal. So, with Bob on the case, I really didn't even have those 5 seconds. I knew we were going to win that issue.
Yeah, well, with Judge Cannoni and some of the rulings, which are questionable, you never know. But so there was no moment of where Bob Alessi is like, hey, I didn't sign up for this. I came to deal with the experts, and all of a sudden you guys are throwing me this huge issue, which is really can be monumental in the case. Obviously, not having Alan Jackson there, he just took it in stride, no problem, and just dug his heels and figured it out. So it's really amazing. It's just coming in cold, cold, trying to catch up, and then this gets thrown at you and it doesn't faze you. It's just like you said, David. There's only a few attorneys in the country that these type of things wouldn't faze. Let me move on to another question, and I know that we spoke. You've spoken about objections, the fact that you're not able to state the grounds on your objections. To me, it's very, very odd. I've never been in any courtroom where they don't allow you to state the grounds for your objections. I've spoken to other national trial lawyers where they've never been in courtrooms where you're not allowed to state at least the grounds of your objections, and there's a fine line between speaking objections and stating your grounds. And you guys filed a motion about it. We analyzed it on our trial and our channel. We were all for it. Like, what is really going on with this? I even spoke to some other Massachusetts attorneys there, and I'm like, is this normal in Massachusetts? Which I learned a lot of things are a little bit different in Massachusetts than they are in some other jurisdictions. But one of the things that I was just thinking about, and maybe I mentioned on my trial a few times, I want to know your take on this, is the fact that you're not able to state grounds in your objections. And, if you wouldn't be able to win the case, and now it gets up on appeal, and the appellate courts are trying to figure out your objections and what the grounds for that specific objection was. And there's some case law about it. But I was just wondering, why not make a record? And maybe you did this at sidebar, I don't know, but why not make a record saying, Your Honor, we respect your ruling with the objections that we're not able to state our grounds, but I just want to make it clear for the record that anytime we do state an objection and you do not allow us to state our grounds, we want all possible grounds to be included in that objection so that it's clear for the appellate courts that anytime we state an objection, you can look back to that record that you make and said, and argue, we included all grounds. So like there was one scary case, I think one of you quoted in the briefs, where the appellate court was left to guess at the grounds, and they guessed one of them and not the other one, and that's how they analyzed the entire opinion. So I was just wondering, was this an idea that you had, or what did you think about how to rectify this issue, which may come up on appeal in case you lose, that you may have meant a certain grounds on the objection, Judge Canoni took it a different way, there was no sidebar for whatever reason, and now you're left at the mercy of the Court of Appeals?
So, first of all, it was unusual to me that we were not allowed to state an objection in a word or two. In most trials I've done over 35 years, I've been able to do that. This, believe it or not, was my first trial before Judge Canoni. I really didn't know her going into this trial. We've both been around for a long time, but our paths just never crossed. For that matter, I didn't know Hank Brennan personally before this trial either. We have a million, mutual friends or acquaintances and colleagues, but just met him as well. It became clear that this was just part of a general view that Judge Canoni had, which is she didn't want any extraneous information coming out of the lawyers' mouths in front of the jury that was not a proper question. So, any trial lawyer will, add their own comments. If a witness says something, you comment on it, then you shift and ask another question. That drove her crazy. And she called us on it just about every time. And I might have been the biggest offender. I think Bob far less so, but I know Alan also got upbraided for that. And so it's all within this same sphere of she didn't want the attorneys passing any information to the jury outside of questioning of witnesses. And that's the only reasoning I can think for her, to prohibit us from saying hearsay or asked and answered or irrelevant or whatever, because I think, and I don't want to speak for her, but I'm just gleaning and inferring that maybe she was thinking that's passing along information to the jury. It's improper. So with that in mind, it was really on us. If we thought it was unclear what the objection should be, to ask for a sidebar and to make our record at sidebar. I don't think that we were shy about doing that. I think that the ruling by the judge that prohibited a lawyer from stating an objection, in open court, led to many more sidebars than in the normal case. And it made it a little clunky, but we were very used to it from the first trial. So, we went in with the same expectations. We just tried to do our job given the constraints and given the rules.
And what would you think about that suggestion? I mean, do you think it's a decent suggestion, as just to really protect the record, to say, I understand your ruling, but just to make sure. I want all grounds to be covered when I make an objection, in case there's no.
I think I think it's an excellent suggestion, and I think we tried to adhere to that during the trial.
And so that will lead us into another issue. And this came up a number of times. I don't think it ever happened with Brennan, which is why it was really irking me. I think it was the first time was with Jennifer McCabe, where Alan Jackson was doing the cross-examination. And you know how cross gets. And there's some issues with what I saw, how loose or not so loose she was on cross-examination, or allowing you to perform what I would think is normal cross-examination. But there was a certain time where literally in the middle of a question, she stops him and tells the jury, I want you guys to be mindful of the instruction that questions that the attorneys asks are not evidence and only answers are. And I think she did it more than once. And I was jumping out of my seat, and, just my own trial instincts was, I'm very into making records, if you can't tell that. So I would say, when the jury's out of the room, I'd say, Your Honor, I don't know what the jury's thinking now. You're admonishing me. You're telling them not to listen to my questions. You're not doing it to the other side. This is starting to look a little bad for the defense. I'm going to have an issue with you, especially if it's in the, what were you thinking about when you saw that happen with Alan Jackson? It happened more than once. Is it just like, oh, here we go again with, Judge Cannoni, or is it, was there some blood boiling where you're going to try to figure out what to do with that?
The way I look at that particular issue is you just got to find a way to get the job done. There are things that everybody saw that happened in this trial, and I can't get into the sidebar conversations, but I can tell you that there were some very robust conversations at sidebar with regard to topics like that and other topics. And our goal is to zealously represent our client. The stakes couldn't be higher with the charges that were here. And so any comments on the attorneys or about the attorney's questions reflect upon the attorney, which therefore impacts the ability of the attorney to represent their client. And what I will tell you is we were on that issue, and we were zealously advocating our position on it. We obviously can't control the outcome with the judge, but we did make our position very well known often. And then we just had to find a way to get the job done, notwithstanding what comments the judge made or whatever else came our way.
And this also kind of brings, at the end of the trial, it felt like after you waited for the Commonwealth to put on their entire case, then you guys got a few days. And then it seems like Judge Cannoni is just, the jury's losing their patience, and she's losing her patience by always going to sidebar and just mentioning just certain comments that she makes to the jury. Okay, really quickly sidebar, or keep apologizing to the jury when you're putting on your case. And there was none of that at all in the Commonwealth's 24 odd days of that they were putting on their case, which I thought at the time, I said, again, it's improper. It could be letting the jury know that you're fed up with the defense, and because you didn't do this for the Commonwealth, and we just started our case, or we're just a few days in, so that was also another moment where it's just screaming at me, is this a time to make a record? Is this something to let the judge know, hey, you're speeding us up, you're telling us the jury's not interested, or whatever it is, and you're making comments, it's got to stop.
Yeah, I'll say what I've said often since the verdict. God bless those 12 men and women of the jury. They saw everything in my judgment that you saw and that the whole world watching saw. And so, as I often do, I put my faith and confidence genuinely in the jury that they're going to see, they're going to know, and they're going to enter that into their calculus. And I'm heartened that I believe that happened. As you know, Martin, there's only so much you can do as an advocate to make sure that the balances are struck, and you get, especially in a criminal case, and especially with the stakes are this high, that you're allowed to present the defense that your client has the constitutional right to under the U.S. Constitution, and Massachusetts Declaration of Rights. And I don't know if there could possibly be any 3 or 4 attorneys who fought more for that to happen than us. So I'm very happy with the fight that we put in with regard to that. In the end, we had to get the job done, notwithstanding what was thrown at us. And the jury concluded that we did.
Yeah. I'll just tell you a quick anecdote. I had a national trial lawyer on my channel once, and he was saying that he was one time in front of a judge who was being very openly, against him and his client. And there's a specific jury instruction which says that if you think that I have an opinion, you should disregard it. And he put that jury instruction up in his closing argument. He says, ladies and gentlemen, I usually don't have to talk about this jury instruction, but I think in this case, you have to really consider it. And he actually won that case.
Oh, wow.
Yeah. But anyway,
that takes some nerve.
The only time he had to do it, but this guy happens to be my brother. But anyway, yeah. So let me move on to another topic. And maybe, again, this is something that's just odd to me. And David, maybe this is something that happens in Massachusetts when it comes to note taking. So in the trials that I've been involved in, sometimes they let the jurors do it. Sometimes they don't. I've never seen where the judge will allow them to take notes, but not during opening and closing. Is that something that's normal for just Massachusetts? Bob, have you seen this in other jurisdictions? Like it's either yes notes or no notes. And just because what the lawyers are saying is not evidence, but we're talking about the evidence, and maybe that will remind something of the jury or the jurors that they're listening to us. Oh yeah, let me look up that exhibit. Let me, refer to that testimony. So this would just seem very odd to me, and I just wanted to get your opinion about that.
So I'll let Bob handle this, but I can just tell you in Massachusetts, I would say this is a common thing. I can think of many trials where judges have done the exact same thing, such that it didn't really faze me because I'm kind of used to it.
My answer is this is the way we do it in Massachusetts, Mr. Alessi. And so to me, okay, that's the rule of the game. To answer your question specifically, my experience is, and I'm in a lot of different jurisdictions throughout the country, if you're allowed to take notes, they give you the jurors a notebook and they can write down whenever they want. And there are some judges, no notebooks. So obviously they don't write anything down, but I have not experienced what we had in the Karen Reed trial. But David just gave you the answer that that's a Massachusetts thing.
It's really amazing. I mean, the more that I've been following this case, the more that I'm realizing how different Massachusetts is than a lot of other jurisdictions. But here's another one. I have never had to turn over my communications that I had with an expert witness or anybody for that matters, because it's 100% work product. So in this case, you guys or Alan Jackson or whoever it was had to turn over their communications that they had with some of the ARCA experts. And to me, again, that just like, whoa, that is like theories. I mean, that could include that, your theories and your opinions and your strategies in the case that you're talking about with the expert, which anyone, and Bob's dealt with experts. You're talking theories the entire time with the expert. We think this happened. Maybe that happened. Can you test this? Can you test that? What do you think about this theory? And if the other side gets to see all the theories that you're testing out, I mean, like seems wildly unfair. And I understand that it was kind of a sanction in this case, but it just was, to me, it was just so improper and inappropriate. Like, give me a fine, fine us. But like the work product which is going to help get my client acquitted, I have to turn that over to the prosecution now. So is this the first time you saw this in Massachusetts, or is this something normal that happens in Massachusetts?
No, definitely the first time I saw it. And I'm going to let Bob handle this question because Bob handled this issue at trial. But the only comment I would make is that, we were accused by supporters of the other side of pushing conspiracy theories and hoaxes. But this was truly the biggest hoax of the whole trial. That's what Bob called it, the ARCA hoax, that, there was something nefarious going on when there was absolutely zero evidence of that. The jury was not allowed to hear it, but we didn't hire ARCA. The federal government did when they looked at this case. ARCA came to all their conclusions well before we ever knew they existed. And essentially, once they were released to us to be able to testify, they didn't vary their opinions. So, my view on it was, it doesn't matter what the communications were, even from a substantive standpoint, because obviously it didn't affect anything. But I do agree with you that it was, somewhat shocking that, text messages between a defense witness and a defense attorney would be made public by the judge. So, maybe I said too much, but Bob, why don't you handle the rest?
But David hit the nail on the head. This was an absolute hoax, and I dubbed it the ARCA hoax. No defense member, and this was about before I was on the mostly about before trial 2. So I was of course on trial 1. It was a hoax, and what the Commonwealth, and particularly Attorney Brennan, tried to do was to get ARCA knocked off. He realized the threat that they were, and from the jump, he tried to get them knocked off. Now, he would say, oh, I'm not looking to get ARCA knocked off. Oh, if they just turn over the discovery, I'll be okay. Every time we did whatever it is he said, he still kept coming back trying to get them knocked off. It was a hoax, and unfortunately, the judge bought the hoax, issued a sanction based on a hoax, but the judge never stated what it was that the defense did wrong. Right? She just said, I find there to be a violation and I find it intentional. Never stating what the violation was, because there was no violation. So it was a sword of Damocles that was held over the defense's head. We still won, and we still ended up putting ARCA on the stand. The last part, Martin, I think it's important to identify 2 parts of ARCA. David's identified part 1, that which they produced in their February of 2024 report, which the defense had nothing to do with. However, the ARCA did have sort of the part 2, which was their new testing. And Judge Cannoni did require that there be disclosure of communications that would cover that new testing. So certainly got into work product. I've never seen that happen in my career. The good news is there wasn't much communication because it was fairly in its nascent stages. But it was something that in the end, in addition to it being a hoax, turned out to be gaslighting, because we learned that actually all that happened between the Commonwealth and Aperture, where they were changing their testimony in the middle of the trial, when there were communications with the Commonwealth's prosecutors, when the Commonwealth said there wasn't, this was a surprise to me, right? And said it was a surprise we got Burgess's report on May 8th, when in fact, Burgess testified that he let them know and had a conversation with the prosecution on May 7th that it was coming. Not one mention of a grave concern or one mention about that conduct. However, in the end, we just look at it as we got to work harder, we got to work smarter. I said it was like a golf handicap. The prosecution may end up with a +2, they may end up with a +18 handicap. We still got to win the tournament, and we did.
Yeah, well, as Brennan said from the beginning, he would welcome ARCA with open arms. He would welcome ARCA, except from the beginning, he tried every which way to exclude them. And then also when you guys made your motion for the communications between our Aperture and the Commonwealth, that was summarily denied. So, yeah, I mean, it's and David, you'll know this, a lot of times the defense attorneys are the ones trying to push and and sometimes the judges push back, and it feels like, they're against the defense attorneys. In this case, it was just that much more extreme, I think. But let's move on to another topic, which I've maintained from the beginning. And again, this may be getting into territory, which, if you choose to move on, that's fine. But I always thought from the first trial that the best defense against the "I hit him" comments was that she was suffering from extreme grief at the time. Every single person who testified said that she was hysterical. The scene was chaotic. It was bedlam. And, it was just, she was beside herself and screaming things. And, so to me, it always seemed like if I got this case from this day one, and again, I don't know all the strategies and everything, but I would have said from the beginning, yeah, maybe she said it, but I mean, look at this type of person. And maybe I even suggested at one point in my videos, maybe the defense should go get an expert and explain this to the jury, that when someone is suffering from extreme grief, they will blame themselves, and especially at the scene. And they were the last people to see them. And again, Bob, you got this out of Dr. Russell, where she said, yeah, that she was suffering from extreme grief, and it's very common for people to blame themselves. So it just makes me think back to, so then why was the posture? She never said it. And then what you have to do is you have to, the three witnesses that are going to testify that she did say it, you have to work on each one to show each one's not reliable or not credible, as opposed to, yeah, maybe she said it, but she was obviously suffering from extreme grief, which are in the medical records, and we're going to have an expert explain to the jury. So if you have anything that you can possibly share with us about that, I'd love to hear it. If not, just tell me to move on.
Well, I had the benefit of hindsight coming in for trial 2, and the defense team did a fantastic job in trial 1. But I had the benefit of hindsight, read the transcripts, take a fresh look at it. And I have my clinical pharmacy background, so I zeroed in on the medical records. And as you note, in the medical records, it was buried. It was just 2 lines. Where in the ER, the doctor made the diagnosis of extreme grief reaction. So I did not bring that out in Dr. Russell. That came out on cross-examination. Attorney Brennan walked head on into that, head on. And I can't get into the strategy, but the timing could not have been better. After clip, after clip, after clip, all the points in opening, and I hit him, could I hit him? And then some people improving their story to I hit him. It all came to an abrupt halt and elucidation with Dr. Russell. And you may recall, Martin, how that occurred on cross. What happened is Attorney Brennan, trying to impeach the eminent Dr. Russell, which takes a lot of courage and just isn't going to happen, said to Dr. Russell, well, implied she didn't really do a thorough consideration of Ms. Reed. And did you consider the fact that she said, I hit him, and, it's the umpteenth time he went at a witness on that. And she said, yes, I did. And then the fateful question of Attorney Brennan. Please explain. Please explain. Dr. Russell moved up in her chair closer to the microphone and explained extreme grief reaction, how frequently she saw it in the emergency room where you would expect to see it. And to me, that if there was any traction given to the I hit him, I think that those tracks ended up being covered. So that's how it happened. And I can't get into anything other than it was something that was a moment that we all enjoyed being a part of.
Yeah. Well, now that you mentioned the clips, let's move into that. So this is something that I was wondering about from the beginning of this trial. I got asked a million questions about it because I spoke about it a lot of times. And that is when you got Brennan cherry picking these clips. And I thought that I knew about a rule called the rule of completeness, which is that you can't do that. And everyone was asking me, so is the defense going to play some clips? How are they allowed to do this, taking this out of context? And I said, look, there's the rule of completeness. maybe if it was me, I would have demanded, no, you got to play the entire documentary from beginning to end, because that provides the context for those clips. You can't pick and choose. You can't cherry pick them. And I don't know if this was discussed. I'm assuming it was discussed amongst you. And I would love to hear any sort of insight into what the defense was thinking about those clips in terms of the rule of completeness and how to help put them in context if that was necessary. And if I need to move on, I'll just move on.
Yeah, in terms of that, all that I think is judicious to state is that there was that was a topic that was addressed internally extensively, and I'm very, very comfortable with what we did and how it worked out.
Yeah, and that's exactly what I would have said. We put on the defense that we wanted to and that we thought we needed to.
And I'm assuming you knew which clips Brennan was planning on playing before he played it.
He showed us in advance.
Right. I mean, he didn't just show you like, here, any of these 58 clips, right? He said, I'm going to be playing this, this, and this, and then the other one.
Yeah, we were notified in advance of what clips were going to be played.
And you accurately note the rule of completeness, and we were very, very cognizant of that rule.
Okay. All right. So I'll move on. So here's another thing that I was wondering about, and this goes to you, Bob, because you were, again, but David, you worked as a team. So, here's the question. When you were cross-examining Welcher, and something that I spent some time on this actually before I even put the video out. But according to Welcher, what happened there was, and according to the testimony, Karen Reed's Lexus was by the flagpole, and that's where it was stopped. And according to Welcher, it went forward 34 feet, and then backwards 34, and then again another 53. So a total of 87 feet backwards. So which means it went 34 feet frontwards, 34 feet backwards, and then essentially back to where it started by the flagpole, and then another 53 feet backwards with her still pushing on the gas, going 24 miles per hour. This is his testimony. And we know where John O'Keefe's body was found. It was right by the flagpole, right? So there's no conceivable way that he was hit at the end of that event of 1162 when it was 87 feet backwards. That would have to mean that she hit him 53 feet beyond where the flagpole was. So there's no conceivable way, even in the Commonwealth's theory, that he was hit by the mailbox. How in the world would he end up by the flagpole? The only thing that would make sense in their theory of the case is that he was hit somewhere around the flagpole, which would mean when she was going backwards 34 feet, maybe 36 feet, maybe you want to stretch it even 38 feet. And then it would have to mean two things. Number one, for some reason, she continued to push on the gas for another 50 feet going backwards after she hit him, and so why in the world would she do that? And continuing to pick up speed, according to the Welcher. She didn't take her foot off the gas. So she's flying down Fairville going backwards after John's already by the flagpole somehow. And then here's the other part. According to Welcher, according to Dr. Rentschler, what he explained was that wherever the tail light busted, then those pieces would have continued to go at the speed of the car, which would mean that those pieces of tail would be continuing backwards beyond the flagpole. So how is it that all those pieces of taillight would end up anywhere in front of the point of impact? So these 2 points I was wondering about whether you wanted to explore during cross-examination. I see that you didn't. And I was just wondering if this was something that was tossed around, this idea of, because Welcher's saying, we have no idea where he was hit. Well, he wasn't hit at the end of this event, right? Because how would he end up at the flagpole? You could have worked backwards with him a little bit, and you didn't. And I'm just wondering if there's anything that you can share with us about these type of thoughts and ideas.
Yeah. In terms of what I can share is, with any expert, you have to pick, particularly with incredibly technical areas, you really have to pick 3 or 4 areas you want to focus on, because if you go into too many areas, it's information overload. And this jury was very smart, but even the smartest people, you give too much and it dilutes other points. And I've often heard jurors in jury focus groups, spend a lot of time with jury focus groups. When you get into more than one-step math with jurors, it's almost a universal reaction. You know, I'm not good at math, or math's not my strong suit. And it's almost like their mind shut off after the second step. And you absolutely correctly do the analysis, but it takes a lot of attention and people wanting to be attentive on that. And all I can say is Dr. Welcher was a rich source of cross-examination material, and there were just higher priority items for me to make the points. And so I chose to do that. But you're absolutely right. It's an astute point. It's just that there were so many other areas to mine, and that's what I chose to do in that regard. So it was a conscious decision.
Well, look, as soon as he got Dr. Welcher to say that the car could have went into space, that was the end of him. So
yeah.
Let me ask you a question, David, because you cross-examined Ryan Nagel and Heather Maxim. And this is something that I was wondering myself when you were cross-examining. I think that you brought this out in the first trial also, but you didn't in the second trial. And I was wondering if there's a reason for that. They didn't say anything about a Jeep being there, and you didn't elicit any sort of testimony about that, which would have directly contradicted Jennifer McCabe. And by the way, Dr. Welcher also discounted Jennifer McCabe about the Jeep being there. So can you share with us about that? Was that something you didn't want to ask them? Was that something you didn't want the jury to focus on?
Yeah, we did that on purpose. And the main reason for that is that their testimony led to such important evidence, which was that John O'Keefe was not in Karen's car. He was not around Karen's car. He was nowhere in the area. And so the point was there was only one other place he could have been, and that was in some part of the house. And so, my thinking was it was a very clean cross-examination to elicit a major point. And, the issue of the Jeep, I think, can be a little confusing. I just didn't think we'd get the bang for the buck to justify taking away from, what was essentially the takeaway from that testimony. The dome light was on. There was nobody in that passenger seat. He was nowhere around. I mean, that was the value in those two witnesses for me.
Yeah, and you made that clear on like your recross, that not that you just didn't see anybody there, but that there was nobody there, which is a very important distinction that you made very clear, which is a good pickup. Let me ask you a question about Yuri Buchanan reading the text messages, because I thought that was brilliant. And was this something that you guys, I mean, you knew what happened at last trial. Was this something that you all prepared for? You were going to do? You were going to get the text message in through Buchanan. That way you don't have to call Brian Higgins. He can kind of be this boogeyman. He looks scary in those videos. And I think I get your point about him on the stand, which he can come across well. I think he did, by the way, in the first trial. And when they cherry picked the text messages, what to read, it looked like he was kind of being strung along or whatever. You kind of felt bad for him a little bit. Whereas opposed to when Buchanan read all of those text messages, you see the entire context of that relationship or what was going on there. It really, to me, was like a really big difference. And it seemed like it took everybody in the courtroom by surprise, except for you guys. So I'd like to know a little bit more about what was going on in the internal conversations, whatever you're allowed to share. But Judge Cannoni was shocked. She's like, you're going to have him read all these text messages? You're like, yeah, exactly. And it seemed like Brennan was taken by surprise. So go ahead.
Yeah, it was a very conscious decision. We fully understood at the moment why people would say, what? These are being read. Why? I had my own judgment about what a full reading of those would be, what conclusions people would reach. But it was entirely strategic. It was a very thoughtful process that came to that conclusion. And I will tell you that my judgment was I could not have been more pleased, and I could not have been more pleased that Buchanan read them. And my own view is just Buchanan writ large. Every minute, every hour, every day that he was on the stand was a benefit to the defense. So in terms of the messages, yes, very conscious, strategic, a very thoughtful process by the defense team, unorthodox as other aspects were, but I was very comfortable with the decision when we made it, and I was even more comfortable after they had been read.
Yeah, I think it made Karen look a lot better, seeing the entirety of the text messages, and then you don't have to call Brian Higgins. But again, I thought it was amazing. That was really strategic and great move. But you don't need my you don't need my appreciation there. But let me ask you another question, David. Maybe this you can answer. Kelly Dever or Dever, depending how you want to pronounce her name. She wasn't called in the first trial. And I'm just curious about why the first trial not, and the second trial, she was obviously a great witness for the defense by her demeanor on the stand, obviously, and by her position. And did you kind of know what her position was going to be already in the first trial? So whatever you're allowed to share with us about that, why not call it?
I mean, it was a strategy decision, and it wasn't a black and white decision. And, it was clear, I think, that we learned things from the first trial, right? We made certain strategy decisions that, with the benefit of time and with the benefit of the lack of a verdict, that, maybe it pushed us in a different direction in the second case. And that goes from, for individual witnesses, whether to call them or not call them. And it really went to our general strategy and defense strategy. You saw in the first trial us really, in retrospect, probably taking on too much of the burden of proof, which I think didn't inure to our benefit. And so I think you saw that we went into this trial really focused on not so much proving who did it or suggesting who else did do it, although there was certainly part of that in the second trial, particularly with Higgins, but more focused on what did the Commonwealth prove? And, this issue of did they prove that there was a collision? That was in the end, the winning strategy, because they really couldn't prove that. And in fact, I think it was more likely that we proved there was no collision, but we made clear that that's not our burden, and we focused on reasonable doubt, and so. Sort of a roundabout way to answer your question, but it just went into us learning from the strategy that we employed the first time and trying to improve things for the second.
So then let me ask you this question, because I have in the back of my mind what may have been the reason for this. Because again, it seemed like from this trial, you guys were much more focused on there was no collision, and that's the end of the story. It doesn't really matter what happened. And again, kind of just throwing some other suggestions that the jury can be thinking about, the video and et cetera. But then if that's the case, I was just wondering, so why even bring up the 227 search? And I have a perhaps a reason why you may have, because you don't really need it at this point. You're not trying to prove that there is a conspiracy or anything like that. So whether she was, Googling that at 227, you're going to have Jessica Hyde and Ian Whiffen say that she didn't. And so just ignore it. What about that?
Well,
you can speak to that, Bob.
Sure. I don't know what you mean by why bring it up, and if you're talking about the second trial.
Yeah, the second trial.
Yeah, we did not put on a witness to talk about 227.
Yeah, Alan Jackson mentioned his opening statement.
Well, it was mentioned in his opening statement, but in terms of the trial itself and the evidence, we didn't put on a witness. I cross-examined Ian Whiffen and Jessica Hyde fairly thoroughly on that, including the deletion of it. But we did not put on a witness for 227. So I think the trial, if you will, speaks for itself in that regard.
Yeah, and I'll just tell you what I was thinking, and you can either nod or just ignore me or give you a poker face on. To me, the reason why maybe I would mention that in the opening statement, like Alan Jackson did, is to have the prosecution chase this animal down this rabbit hole and spend time of the jury where you're not even going to make a big deal about it, but it's a distraction essentially for the prosecution to get all hung up about it and get Ian Whiffen on and Jessica Hyde to dispute this search, and you don't even mention it again. So to me, that may have been the strategy there, but I'll move on. Let me ask you
in
a
the
question.
words of in the words of the eminent Dr. La Posada, there was no collision, so it doesn't matter.
Exactly. Let me ask you a question, because I was just wondering, as just evidence, when McLaughlin was presented with the Facebook posts with pictures of her and Caitlin Albert, can you kind of explain why that would not be admissible if she authenticated them? They're very clearly the people who they say they are. Their impeachment. Just maybe if you can explain, if you can, why would they not be admissible?
Well, we obviously felt that they should have been. We got ruled against, and
Was there a
what
reason?
can we say beyond that? I didn't make the ruling, so I can't tell you what the reason was.
Yeah, and I will say I taught law school for 5 years. One of the courses I was most focused on was evidence, and I am not able to come up with a basis in evidentiary law for the exclusion, but it was just another item where it's okay, you're not going to be allowed to do that. Go find a way to get it done.
Yeah, and it kind of puts me in a hard position also when I'm covering this case and I'm supposed to be this trial lawyer, and people are asking me, "Hey, what's the reason for that ruling? What's the reason for that ruling?" And I'm like, "I don't know. I can't explain it to you. So it makes me look a little bit.
Well, Martin, I would feel bad for you, except you didn't have to be at counsel table.
Yeah, I feel worse for you. Don't worry. Let me ask you another question, because I think that this is what happened again, and this is just me putting myself in the position, and it looks like this is what happened. You can either, admit, deny, or no comment. It seemed to me, and this is something that I always like to do when I've got some bad information that's going to come out with a witness, I always like to get that out. I don't let the other side bring that out, because it's going to be a lot better when I bring it out. And it seemed to me, and correct me, it seemed to me that Alan Jackson really wanted to talk with Dr. Wolf about the Signal text messages and the fact that he deleted it. It seemed like that's where he was going. There was an objection. There was a sidebar. And then he moved on to a different area. And then Hank Brennan got to get up and talk about those Signal app and that encrypted, app, and the fact that they were deleted. And knowing Alan Jackson being this amazing trial lawyer, I would assume he's at least as smart as I am, and I know he is, and that he would also want to get in front of those type of things. To me, and this is what I speculated to my channel, is that for whatever reason, he wasn't allowed to.
Yeah, it was discussed at sidebar, and therefore, we can't say anything about it. And hopefully someday those sidebar records will be unsealed, and we would be able to have a conversation about it. Let me just say one thing. The whole Signal thing was just a hoax.
Yeah.
anybody that knows, and this is one of the issues you run into sometimes, there's different levels of understanding of the technology in the world. And I do a lot of cases with technical information, and there's some parts of the judiciary, and there's actually manuals on scientific evidence, especially in the federal courts. Everybody knows WhatsApp, right? And WhatsApp is encrypted. It signals the same thing. There are other encrypted apps. iMessaging is encrypted, right? And you can put settings on those that they evaporate within a certain amount of time. Signal's no different. It's just a little bit better. And the bar associations and the codes of professional conduct have not said anything adverse about using Signal, etc. It was just another hoax perpetuated to make an attempt to get ARCA knocked off of the case. And, you know, as you know, Martin, you're an experienced and well-regarded trial attorney. You do try to get ahead of matters. And that's what you do. And that was the attempt to do that was not successful in this instance.
And Bob, again, let me ask it this way: you taught evidence, like you said, for a couple of years. Can you think of a rule of evidence that would be applicable to why an attorney cannot ask that type of question?
I can, but I don't think it would be correct. And that would be trying to what they call anticipatory rehabilitation. In other words, you're not supposed to be able to buttress your own witnesses' credibility until they are impeached. And that could be, I don't think it's persuasive. I don't think it is convincing, but that could be an argument made to prevent that. But if that were the case, you would not, as an attorney, be able to get ahead of many things and put things out, because it would always be couched in the bucket of you're anticipatorily rehabilitating your witness on direct, and you can't do that until they're impeached. Again, that's just as a guess. I don't think that would be a valid reason for it to happen.
Yeah. Okay. All right. So let's move on to an issue that we were all thinking about here. And I was thinking myself about the verdict form and the fact that the plain OUI was added this time. And when I first heard about this, I actually thought that the prosecution added that charge because they wanted to get something, so that was my first reaction. I was like, well, it must be the prosecution is feeling so desperate that they lost this case that they got to get some sort of conviction, and that's why they're adding it. And then I found out that it was the defense. So then I was thinking the following. I was like, okay, I understand why the defense would want to add that, so that the jury can feel like, oh, well, she should get something. And I understand that idea. Well, here's where I was getting a little bit more nervous about that idea. And that is where, for some reason in Massachusetts, if you hang on a lesser included charge, then it's considered being hung on the entire charge. So when the jury was out deliberating for a couple of days, I even tweeted this out, that there may be some people in the jury room that are so disgusted with this investigation, so disgusted with Michael Proctor and, the entire case essentially, that they may be feeling like we are not going to convict her of anything. I don't care whether there's enough evidence to convict her. I'm not voting guilty on anything. And then there may be some other people in the jury room that will say, look, I think we should convict her on this. And then what you're left with is a hung on the plain OUI, which would then, for some reason in Massachusetts, again, another oddity, be considered a hung on the entire second charge, which would mean that you'd have to then ask the judge for partial verdicts, which we know what happened in the last trial, but I'm sure this time wouldn't. So you'd find not guilty charge 1, not guilty charge 3, charge 2 hung on, and then the Commonwealth will be able to try the entire charge 2 again. So that's where I was thinking maybe not to even add plain OUI. So this must have been
it's such a smart point, and I suspect that is what the jury was talking about toward the end of their deliberations. I suspect that there were people on that jury that did not want any charge to be guilty. So, it's a consideration. Again, you get into, and Martin, you know this from your own trial practice. I mean, you're playing the odds, right? You're making decisions in real time, based on, is there a greater risk or is there a greater reward? If it's 60-40, maybe you choose the 60% chance, realizing that 40% is a pretty good chance that the opposite might happen, right? So, we made the decision that we did, thinking that it would facilitate a verdict more than obstruct a verdict. Whether that is ultimately true, I can't say. But we weren't afraid of an OUI conviction. And at the end of the day, if anybody was holding out for a not guilty on the OUI, God bless them. We love them. But thank you for contributing to the verdict, because we certainly did not want to try this case again.
Yeah, and Bob, you can chime in on this also. This is just one of the most troubling things about this verdict form, that you can hang on a lesser included, and the jury wants to acquit her the worst way of all the serious charges, and there's no way to do it. It smells to me like unconstitutional. The jury wants to acquit this person of all the serious charges. They just want to hang on OUI, for example, and they can't. And the person has to get charged, retried again.
Yeah. Listen, you have in the other cube here with David Yannetti, the master of jury verdict forms in Massachusetts. So he's the best person to speak to that. I will speak to the constitutionality issue that you bring up, and I think it's a real one. The whole goal overall, and again, David will speak to Massachusetts, is to make it's supposed to be a tool for the jury. It's supposed to aid the jury in making their decisions. And this verdict slip form, to me, did anything but that. I think it had the counterfeit. You could just tell by the question that came out. So we have to remember what the goal of a jury verdict slip is. And this verdict slip was not serving that function. And secondly, to basically have the specter on a murder two in a manslaughter, to hang a jury on an OUI, a lesser included, is to me to deny the defendant a due process. And it's a due process violation, in my view, a due process of law. So it's a combination of a fair trial and due process in this verdict slip. And I understand it. Again, David can speak to this. This can happen a bit in Massachusetts, not just in this courtroom. We got a little bit of movement on the jury slip form after the jury came back and did what we predicted they would do. And I think that was helpful a little bit. But there are dimensions that you appropriately note, and specifically due process and fair trial, that I think were very, very much implicated in this slip.
Yeah, well, David, I think somebody in Massachusetts should take this up. I mean,
Well, certainly we tried with regard to the post-juror contact that we had related to count two from the first trial, but not this specific issue.
right.
I think, and again, I can't speak for Judge Cannoni, but I can speak as a longtime, criminal defense attorney and former prosecutor, decades. There's a difference in Mass, practically speaking, between civil jury verdict slips and criminal verdict slips. it's very common in civil cases to have special verdicts and just the jury asks certain questions and answer questions. And then, the decision tree, well, if you answer this way, here's another question for you. If you answer that way, you're done. We tried to propose something like that. And our initial attempts, I think, were ineffective. I want to give credit to one of our legal interns who just graduated valedictorian at the best law school in the country, Boston College Law School, where I went. He
Well, I gotta
actually
say, David,
came
that
up.
I think Judge Lou teaches there. But yeah, go ahead.
This intern came up with what we thought was the gold standard in terms of what we were actually looking for. I think we just had tunnel vision, and we were really trying our best with three talented attorneys and me. We all, I think, came up with the best that we could do, and it took a law student to say eureka. We presented that to the judge. She rejected it. But as Bob said, when the jury came back with questions about the slip, just because it was so confusing, I won't say she adopted it completely, but she came pretty close. It would have been nicer if she adopted it completely, because then the form would have been completely filled out all the way down to the OUI, and it would have been so clear. As I'm standing there waiting for the verdict to be read, everybody was still confused, despite the fact that it had been, corrected to a large degree. Because remember, the foreman was asked about count 2, and he said not guilty. It was like, I think everybody on the jury was like, we want to make sure that this can't be misinterpreted, that she's guilty of anything but for that misdemeanor OUI. So, if he was going to have, he asked about, count 2, and he's going to choose guilty or not guilty, he's going not guilty first, and then you could follow up and ask further questions. And that's what was done, and then, it was at that point that I still didn't know for sure what the verdict was going to be. I heard not guilty, but I was like, the clerk's kind of hesitating. What's coming next? It's not time to celebrate yet. And then finally, when the clerk said count 5, specifically count 5, I was like, okay, all right, now here we are, And then of course we had to wait for the verdict on count 3. But no, you raise a really good point. My hope is that verdict slip in this high profile case causes judges across the Commonwealth to just sort of reevaluate, is the jury verdict slip actually really clear so that nobody can make a mistake? Something good will have come out of this.
Yeah, 100%. Well, I appreciate you guys giving me so much of your time. I know I'm a little bit over right now. But I do know that, God willing, we're going to be hearing more from the Bob and David show coming up soon. We just don't know exactly what it's going to look like. I hope you keep us all informed about what's going to happen. But we're really looking forward. And I feel so humbled that you came on to Brother Counsel right here. And we wish you a tremendous amount of luck, and whatever you're doing in the future. You should just have the best. And you guys did an amazing job. Obviously, you don't need me to tell you that, but it was a great trial to watch in terms of trial lawyers and strategy, and being able to research, and the writing was phenomenal. It was just really just a great trial to cover. And I really, really appreciate you guys coming in and joining us today.
Well, Martin, thank you for that. And again, very pleased to come on the show. I want to say to your viewers and to you that you have a very, very talented approach, and it's, I think, unique in some aspects. I was always impressed. You were able to, in a 30-minute usually format, cover a vast area of topics, and it takes a lot to be able to do that. And you have a special talent. You're very efficient. And for those who don't have the time to listen, didn't miss, in my view, a beat. And how am I able to say that? Is because every once in a while I used to tune in during the trial to your 30 minutes. I agreed with you many times. There's sometimes, just as lawyers do, we might have had a different perspective, but I just want to commend you. It's a great example of someone who is a very good trial lawyer, who actually is in the well, knows what the issues are, but also can read between the lines and give your viewers great insight from experience and do it in a very concise manner. And the fact that you were doing real-time legal research on certain topics and coming up with cases and talking about the case names, for those that really wanted to have that sort of extra law nerd factor, I thought you provided an additional value to your viewers. So I tip my hat to what you do and how you do it. And coming on your show was just great to be able to speak to you about matters that I know you have a high skill and level and aptitude for.
I would add to that little anecdote. During the trial, there were many times, I had a front row seat. Everybody else saw it on television that, Bob would come back to counsel table and I'd be like, how did you know to do that? And Bob revealed early on in our professional and personal relationship that he was an Eagle Scout. And I hope I get the signal right, but he would just go like this. Is that right, Bob?
It's
he would
exactly
just
right.
go like this, and he would say, "What's the Eagle Scouts model? Be prepared." And the reason I bring that up is that it was very clear from the very thoughtful questions that you asked tonight, Martin, that you did a lot of prep for this interview, and my hat's off to you. I mean, you have an innate sense of what questions to ask and what would be interesting from a legal standpoint. But it was clear you gave a lot of thought to this. So it was my honor to appear with you, and thanks for inviting me on.
Well, thank you guys so much. Wow, I feel so good. Maybe I can retire now after, but maybe I'll wait for David Yannetti to say that I'm one of the greatest trial lawyers in America. Then maybe that I'll wait for.
I want to see you in action, and then we'll see what percentage of the Alessi standard you can live up to.
All right, sounds like a plan. You let me know when the next case comes across your desk that you need some extra help. But thank you guys so much again. Appreciate all the nice words, and I hope to see you and be in contact with you guys in the future.
All right. Thank you again.
Thank you. All right, guys. Well, that was it. I mean, that's really just amazing and really, really nice words from David and Robert about me. I mean, I did not tell them to say that about me. I promise, I did not tell them to say that. That's just really nice because they're just upstanding, really good attorneys. And that it's nice for them to coming on to my show to, help my show because I'm still relatively, young and small and I'm still growing. So, I mean, really, these are people that every single station, every single creator, everybody wants them right now on their show. And the fact that they'd be willing to spend some time with me is really just so humbling. And to be able to talk lawyer stuff, I still have some more stuff to talk with them about, but they were so gracious with their time. So I didn't want to keep them any further, but who knows what they're going to be doing in the future. I'd love to collaborate with them again. Hopefully we will. We'll keep in touch. But in the meantime, I do want to get to some of the comments here, and I appreciate the comments and the super chats here. So let me get through some of them. Hopefully, we'll try to get through this pretty quickly. Bev's Bangs, member for one month. So excited to hear the Yannetti bromance. Yeah, I mean, you can tell those guys are just best of friends. Sometimes, going through something like this, a trial like this, fighting for the truth and justice, it'll do it to you. So you see that, and it's really beautiful to see. Janice Vetter, by the way, I've had that also with some of the cases. And by the way, sometimes with other attorneys, I'll be on one side and the other attorney will be on the other side, and we'll be fighting like cats and dogs in the courtroom. But that also can sometimes bring you guys, together and have a certain relationship. And I've got some great relationships with some of the attorneys on the other side that I'm fighting against. But here is beautiful to see. Janice Vetter, after hearing Michael Easter discuss this case and the lack of information, why couldn't you obtain further information that the Commonwealth missed as part of their investigation regarding cellular data? Okay, well, I guess this is a question more for them, and I apologize. I didn't want to put on more questions because I had a whole bunch of questions. If I was going to get through them, I would have put on those questions. But yeah, I mean, Michael Easter would have been a phenomenal, very interesting witness to hear from because, he had a lot of experience, and that would have been really, really interesting. Unfortunately, we didn't get to hear him. Amy Reeves, new member. Thank you very much for that. Kim R. Why 2 appearances are so much better. I was very disappointed with how you were treated in Canton Confidential. Well, I didn't see the entire Canton Confidential interview, but they did get interviewed by the NBC 10 Boston tonight, and I guess maybe they weren't treated well. You got to treat these guys well. Congratulations on a hard-fought win. You were really fighting for us. Gold Star and first-class men. Got to agree with you there. I'm sorry if I'm going to mess up the names here. Ashley Girl Alice, new member. Thank you very much. We got a super sticker from Vanis Panikia. $1.99. Thank you very much. Nana Beer. Love these guys. I hope I'm one of the guys that you're referring to. Florida fan. Thank you, gentlemen. Job well done again. My own opinion, some very shady obstacles. Yeah, definitely some shade going on here. Again, Asigul Aksu. I'm sorry if I'm saying your name wrong. Wondering if mankind in power abandoned their duty in favor of protecting a narrative. Don't we need systems deontologically responsible since humans are not? Will we let justice is a hoping system in which nobody asks much? That was a very complicated note there. I'm sorry about that. Charlie Robertson, thank you very much for that. Nikki, has David heard if she runs all trials that way? Well, we heard certain things that the way that she runs the trials. And again, this was her only trial that David was in with Judge Cannoni so far. This was the only trial that he's had in front of Judge Cannoni. And again, from a Siegel Axel, maybe we need AI judges that will be programmed to be morally good. Look at that comment. AI is just taking over everything. Mind journey with Lori Donnelly. First responders know when they look at the eyes if someone had a fatal injury, that brain injury. Churacity. How do they feel about constantly being told to move on when Brennan never was? I know there's a lot of that in this case. That's something that we mentioned. Like, the end of this trial where the Judge Cannoni just hurrying them along and huffing and puffing every time they have to go to sidebar because of her rules, by the way, because you can't, your objection that every time you have to talk about the objection, you got to go to sidebar. So she's set up these rules, and now she's getting tired of them. And it's the end of they're just starting their case. Not a word about it during the Commonwealth's case. Look at this again. Siegel Axu, 50 Brother Council memberships. Wow. Appreciate that. Paul Youngs, gentlemen, salute. Ecola T. I love Mr. Alessi, Mr. Yannetti, but I admire the ladies in the defense team even more. Dr. Scordi-Bello is fantastic too. Yes, and you know what? One of the unsung heroes in this case is Eliza Little. I don't think a lot of you understand, like, you maybe not heard a lot from Elizabeth Little, but let me tell you, as a trial lawyer, you need somebody there who has an encyclopedic knowledge of the file, of the case law, of the research, and that was who Elizabeth Little was. And a lot of trial lawyers, they're very good at certain things. We have a certain skill set. But a lot of times we don't have the encyclopedic knowledge of somebody else at the table who is there that when you need a document, they can pull it up. Or when you're talking about an order, they know exactly what order, where it is, how to find it, what the language of the order is. And I mean, she's one of the unsung heroes of this case. I mean, maybe she is sung, but something that I noticed as a trial like that definitely seemed to be part of her job. And she did a lot of the writing, seems like. She's in charge of that, the research. So, not enough could be said about the women that were helping out, and also all the interns. Churicity. I'm sorry if I'm saying her name wrong. How justified were you when she said, "I have one"? How do I justify all these text messages with that one rule? Leslie says that about clients, and she cut him off like she didn't just ask him a question and said, "You're going to win." She knew. SD the bestie, can you explain why there was no explicit attempt neutralize the alleged "I hit him" statements by calling on a mental health expert? Just curious. This is what I was suggesting, by the way. This is one of my suggestions that I had. Why not hire some sort of expert to explain this to the jury? This is something that we spoke about, but they did eventually get it in. So they weren't able to talk much more about the strategy, whether just to go with that strategy. Because again, I said, I think that should have been the strategy from the beginning. Don't try to say she never said it. Say she may have said it, but she was going through this grief, and you have this expert's going to talk about it. So that's the bestie again. Were you ever concerned that some of the technical info would go over the jury's head? How do you know where to draw the line? And this is exactly where you need somebody like Bob Alessi, because you need to know exactly what line you can toe with the jury. Some of this is very technical, and that's kind of what he was telling me about when it comes to Dr. Welcher. And it comes, some of the additional information that I was bringing up, some of those points, so that was something where you just have to have the experience to know a jury can handle only this much. And that's something that he was able to realize, and something that he does extremely well. He knows exactly how much information or technical information the jury needs to acquit the client, and then anything more, even though like I may have some good points, but he believes that it's just going to go over their heads, and you already made your points. And that's something also, you can't always go for everything. You got to know what to leave. That's just part of the skill of a trial lawyer. Can't chase every rabbit hole. Bob Yannetti, we are the champions. Kimberly G, thank you for that, becoming a new member. And then we have another Asegio Axu, again, gifted 20 Brother Council memberships. Wow, well, thank you very much. I mean, Asegio Axu is very generous tonight. Ipsy Dixon, become a new member. Thank you for that. Teddy 617. Just a little tip for future interviews. Don't focus 95% of your questions on what they didn't do. Maybe focus on what they did do to get an acquittal, but that's me. And okay, well, look, I mean, if you want to do the interview next time, you can ask the questions the way that you want to. But part of the challenge of going after all of the other people that interviewed them already was you've already heard a lot about what they did. So one of the things that I like to do is you learn a lot of information. You learn a lot more from what they didn't do. Sometimes it's a lot better. You get better information, like, why didn't you do this? You learn a lot more. We saw what they did. We saw that it was effective. We saw we can learn from that, but you can also learn from what they didn't do. And that's a lot of times you learn more from that, which is why that's some of the things that I'm interested in as a trial lawyer myself. Lisa Paxton, thank you, Brother Counsel. You were phenomenal. Thank you very much. All right, guys. Well, it looks like that's going to be it for tonight. Wow, what a tremendous privilege and honor to have the David Yannetti and Robert Alessi for this interview. I think it was some great questions, some great insight into their strategy, as much as they could share. But I really enjoyed the conversation. I hope you did too. And that's going to be it for now. So it looks like Brian Koberger is supposed to be taking a plea tomorrow. We'll see if the judge accepts that plea, because I see that there's some sort of movement that he should not accept the plea. So we'll see what happens there. But if he does accept the plea, then it looks like we're not going to be covering Brian Koberger, because it's going to be over. And then it looks like we'll be able to cover Brian Walsh. That's another Massachusetts case, which should be coming up in October. And perhaps before that, we'll be covering Donna Adelson. So that looks like what our future is going to be. And we'll see if there's any cases before that we should cover. So one more great interview from Michael Boyle. Thank you very much. Member for 6 months. All right. And all right, guys. Well, thank you again for joining. And I'm just on a high, probably be on a high. Probably won't be able to sleep tonight because that was such a great conversation. And we'll see what Bob and David, what they have in store for everybody else, because it seems like they got something up their sleeve, something cooking in the social media world. Maybe they're going to start their own podcast or YouTube channel. So we'll see about that. Maybe we'll have more conversations. All right, guys. Well, thank you again very much for joining. And we will, like always, see you next time.